Good morning. I'm Dorothy Anderson, Assistant Bar Counsel. Couldn't help notice that the court doesn't seem to be too pleased with Bar Counsel coming up here and asking for different sanctions in these cases. I do want to mention that in this case, the hearing committee, after hearing the facts, seeing the witnesses firsthand, ordered a public reprimand, and it was only the board and the single justice that then took that down to an admonition. I also want to mention that there's, I believe, an important issue in this case, and that is the question of what is harm in a disciplinary proceeding. And one of the things that concerns us about the decision of the board in this case is that they found that Mr. Dragon, Harold Dragon, the victim in this case, suffered little, if any, concrete harm. And they did that basically because Bar Counsel did not prove the usual standard of monetary damages in the civil action. So
is it Harold or Henry?
Harold.
Okay.
So this was a case in which, when we took this to hearing, there was a malpractice case pending, and there was also a foreclosure case pending. There was no evidence introduced at trial because of these proceedings were pending as to what kind of a settlement resulted from the malpractice case, or whether or not there was any money left over after the foreclosure. And based largely on that, the board was concerned that we hadn't really proved that Mr. Dragon had suffered monetary damages. Well, that's not what harm means in a disciplinary proceeding. Harm is a much broader concept, as this court ruled in the Wise decision in 2000. Now, this is a situation in which the respondent's client had gone to him for this very simple transaction just to have this mortgage discharge changed. The respondent, Mr. Dragon had taken a $75,000 mortgage on the son's property. And the respondent acknowledged in his testimony that, he understood that at least part of that had to do with protecting this son, this ne'er-do-well alcoholic who was very marginally employed from himself. So Mr. Dragon signs this document, one original, takes it with him in 1995, and that's the last he ever hears or sees from the respondent. Now, 6 years later, out of the blue, the son goes to the respondent's office and says, do you remember that document? I want to record it. And the respondent looks in his file and finds a document, and clearly he understands, there could be no question in any attorney's mind, that the son's interest is directly adverse to that of the father. The son owed the father $75,000. The mortgage secured that debt, and the mortgage had been recorded, duly recorded. The discharge was not to be recorded. There was the hearing committee very explicitly rejected a lot of the respondent's testimony in this case. The hearing committee basically said, we don't believe the respondent's story. We don't believe that he thought that there had been two originals. We don't believe that he understood that this discharge was supposed to be recorded when Mr. Dragon became ill or died. And we don't believe that when the son came to the respondent's office in 2001 and told him that his father was dying, that he checked this in any way, shape, or form. And we don't really understand, and it was inexplicable why, if that is really what happened, he, knowing that the son was asking him to do something completely adverse to the interests of the father, would not even check this story that the father was ill. So what was the harm to Mr. Dragon from his point of view? Well, all of a sudden, in 2002, early 2002, he calls his insurance company and discovers that he is no longer holding the first mortgage on this property. He then speaks to the respondent and finds out that the respondent recorded this photocopy of the discharge. He is very upset about this. The hearing committee had an opportunity to watch his videotape deposition, and they observed his reactions firsthand. he calls the respondent's insurance company, and they say, well, we're not going to cover this claim. This isn't, something that's covered by the policy. He then brings this malpractice action. That's pending. In the meantime, the son has already, I'm skipping around too much, but after after the discharge is recorded, the son immediately goes out and gets a new loan for $80,000 on the property. Sure enough, within a couple of months, he's defaulted on that. Now the new mortgage company is foreclosing. The father has no idea what's going to happen to this son, who he was trying to protect. And the malpractice case is pending. The foreclosure proceeding is pending. And that's where things are when Mr. Dragon dies in February of 2004. And to say that that is not harm to Mr. Dragon, I think would go against the perception that most members of the public would have if this was their experience with their attorney. If you go to an attorney to get something done, and this is what you wind up with, you feel like you've been harmed. And this court, often says in disciplinary proceedings that the purpose of the proceeding is to protect the image of the bar, in the eyes of the public. And I do not think it is consistent with that goal for this court to say, no, Mr. Dragon didn't suffer any harm here that's worthy of our protection. This is basically a no harm case, and we're going to give him an admonition. I think one of there's two problems in this case, perhaps, that has led to the status that is in now. One is that it's a family affair, and perhaps the perception of the board was that, this is something between family members,
There's no indication that that's the case. In fact, we've got a whole series of cases where they are all family cases. The fact that children do things to that financially imperil their parents is frequently litigated.
Your Honor, I'm glad to hear that. It's hard to imagine that this would have been the result had this been an arm's length type transaction where an attorney representing another person in this position had recorded a photocopy of a discharge, thereby resulting in the discharge of a substantial mortgage. That would be interpreted as a no-harm situation. I think the other thing that was questionable in this case was what was the respondent's motive. And the board concluded that he had been duped by the son. Well, there's no evidence of that. That's not what the hearing committee found. The hearing committee was very skeptical of the respondent's testimony. It repeatedly said, we don't believe him. And it didn't say anything about him being duped. They basically, couldn't figure out what his motive was, I think is the best you can come up with. And it did say he wasn't acting out of self-interest, but why he did what he did, it will never be known. So I don't think there's any evidence there that he was duped. And to the extent that that influenced the board and towards reducing the sanction here to an admonition, I think it was a mistake. This court has often recommended that Bar Counsel look at the ABA standards when trying to decide what the appropriate discipline in a case is. Under those standards, this would at the very least be a reprimand case. Clearly, there was potential injury. You cannot possibly say that where an attorney records a discharge of a mortgage at the behest of the mortgagor, that there is no potential injury. This is also not a case where the respondent attempted to analyze what he saw was a conflict of interest and just made the wrong decision. This is a case where he looked a conflict of interest squarely in the eye and just didn't do anything about it, did not even seek to tell his former client that he was getting involved in this situation. So under the ABA standards, I don't think there's any question that this would have to be at least a reprimand. And I think if you look at the cases that this court analyzed in the Wise decision, the cases in which reprimand had been ordered, and those include Dionisi, Warren, Frank, and Roberts, that those cases are certainly no worse than this case, that the respondent's conduct here was very comparable to the conduct of the respondents in those 4 cases, Roberts, Dionisi, Frank, and Warren. Thank you.
Thank you. Mr. Sharkey?
Madam Chief Justice, and may it please the Court, my name is Patrick Sharkey, and I'm here to speak on behalf of the respondent. Bar Counsel has lost the argument for suspension 3 times, once before the hearing committee, once before the full board, once before single Justice Cowan, who did decide the case.
If this had not been a father and son relationship, and the client, father, lost $75,000 as a result of wrongfully filing a discharge, I mean, that would be a serious matter, wouldn't it?
Sure it would, except the record doesn't show any proof of loss, and that was Bar Counsel's burden, to show proof of loss. Secondly, the fact that it was father and son is very important in this case. Bar Counsel would have you believe that everybody was very much at arm's length here and that respondent had absolutely nothing to go on. The facts, as found by the board and in the record, show something quite different.
Found by the hearing committee or the board?
Before the hearing committee.
Okay. Which I assume were adopted by the board.
Yes.
But you're not suggesting they were inconsistent with the hearing committee? Okay.
I think that you can certainly look at things very, very differently when a father and son come together, not for the purposes of changing a discharge that's an error, but for purposes of providing a homestead for the son. In the context of that consultation jointly, there was a second consultation right within the same room, same participants, in which Mr. Dragon asked respondent to please look at the mortgage discharge, which he had signed. And bear in mind that this was a discharge signed in advance, and you have to ask yourself, why is that? And one of the reasons that emerged during the course of that discussion was a very inconvenient fact. This mortgage at that time, 1995, had been in existence for 2 years. There hadn't been a single payment. And Bar Counsel herself had said the mortgage was placed on the property to protect the son, per what Mr. Dragon said. No payments requested, no payments made.
Was consideration given for the mortgage? Was there...
Yes, Mr. Dragon financed the construction of Thomas Dragon, the son's house. So there was consideration, and that's not in dispute.
Consideration from whom to whom?
Mr. Dragon advanced the construction funds.
To the son.
To the son, who then built the house, and the mortgage was on the house property.
Oh, okay, I'm sorry. Yeah.
Okay, but they come together not as adversaries, almost as joint clients. And respondent said he learned, and there's nothing in the record contradicting respondent's testimony in this regard, he learned that the payments hadn't been made. The record is pretty clear that even through 2000, even up until the time of the foreclosure, no payments had been made on that underlying promissory note secured by the mortgage. None had been asked for, and none had been received. This was a fake mortgage in the nature of a spendthrift type arrangement. Something else happened. And even though, and this is critical to Part 2 of the case and why we're here as cross-appellants, due process was not given to respondent because Bar Counsel withheld critical documents which would have assisted greatly the cross-examination of Harold Dragon. We pointed out the Holyoke Street Railway case for a particular reason, where you have thin proof. In this case was basically a he said, she said case, where respondent said during the course of that consultation, I was told by Mr. Dragon that if I learned that he was dead or seriously ill, I was supposed to go ahead, if requested, and record the mortgage discharge. Remember, it's unusual to have a mortgage discharge signed in advance. It's a simple document to prepare. So why did Mr. Dragon do that except for the reasons that respondent thought? Respondent acted in good faith, and remember, there's a specific finding by the hearing committee that he believed in good faith, that when he went to record the mortgage discharge, he didn't have a copy, he had an original. So look at it from respondent's viewpoint. He goes up and he records it with trained professionals who cannot accept a copy. they can only accept an original. So respondent thought it was an original, and the witness who testified before the hearing committee thought it was an original.
Weren't you allowed to reopen the proceedings to?
Yes, we were, but we were shortchanged.
You were.
Yes, we were, because we filed a request for a hearing conference to set a schedule so that we could lay out our arguments in detail. We could review that videotape deposition of Harold Dragon together, and then the board would have to, the hearing committee would have to slow itself down. When they got that request, when the remand order came in, this was old business for them, and they gave us very short shrift. So we didn't have the pardon?
What do you mean they gave you short shrift?
We didn't have the opportunity to come in and argue. I was new to the case. I came into the case. I was the one who asked for the additional documents, just on the notion that there had to be more medical records. And oftentimes you find in medical records after a particular date evidence or information that's important about what happened on a prior date. So I asked for those medical records, and I also wanted to get before that hearing committee in order to get them to slow it down and realize it was critical to figure out, was Mr. Dragon's memory accurate or was respondent's memory accurate? That's the evidence that they had to deal with. There wasn't a whole lot of other things corroborating. It's a little bit like the spoliation case that you heard about an hour ago, where you have a thin record and credibility is at the heart of the matter. And remember, if the finding had been that Mr. Dragon had told respondent, or respondent's memory had been credited that he had been told, he would not have been acting in conflict with Mr. Dragon's interest when he presented the mortgage discharge for recording. In fact, he would have been acting exactly in accordance with what Mr. Dragon asked him to do. If you don't have a conflict of interest in this case, you don't have any basis for any discipline at any level whatsoever.
And Mr. Sharkey, what was the hearing committee's finding on that point?
That they believed that Mr. Dragon did not tell respondent that should he die or be in serious health, that the mortgage discharge should be, which he signed in advance, should be recorded. We needed a full and fair opportunity to go forward and present to the hearing committee. And Justice Graney, I think this is very important. Once somebody makes a credibility determination, isn't it harder, far harder, to get them to undo it? Because they've already decided it one time. And it's not just that respondent was deprived of that opportunity. He was deprived of that opportunity by Bar Counsel's decision not to turn over the records before that hearing closed and before that credibility determination was made. We've pointed out in our brief that records were subpoenaed, that trial counsel for respondent asked for copies of the records that are subpoenaed. There's a rule that says when Bar Counsel gets that request, you have to turn over copies promptly. Bar Counsel got records from two sources that were relevant. One source delivered them on October 6th. The second source delivered them on October 10th. Promptly means the next day, 2 days later. Instead, all that happened was that Bar Counsel went to the second scheduled day hearing on October 15th and had culled part of the records, the part that was helpful to Bar Counsel, and submitted them as an exhibit and failed to tell respondent's trial counsel, there are more records over there. You can have them if you want them. There was no notice given. I submit that you cannot, on a credibility decision, which is critical, where there is only what he said and what respondent said, you can't unring the bell later on paper, without even seeing counsel who's going to argue the point about the credibility. That's why we were shortchanged. But it was Bar Counsel's failure to simply do what the rule required. And it was those documents which weren't turned over which explained that Mr. Dragon's memory of an event 18 months ago was wrong. And further, that Mr. Dragon was either wrong or perhaps even lying about why it is that he actually had to go into the hospital on February 5th. He claimed it was because of a phone call which upset him. He fell and he hit his head on a coffee table. We learned from those records that he had fainting spells the entire weekend. February 5th was a Monday. He had fainting spells on February 3rd and 4th. So he was mistaken as to dates, and he certainly was doing more than gilding the lily as to what the cause of his physical harm. Those things would have showed that he likely either had a bad memory or wasn't telling the truth about who said what to whom at the consultation.
Thank you, Mr. Shaw.
Thank you.